Hello, my name is Winn, and my presentation will be on the Furman vs. Georgia case. The death penalty is an extremely controversial topic in the United States. The Eighth Amendment to the United States does not allow cruel and unusual punishments. According to the Supreme Court, cruel and unusual punishments include torture or lingering death. William Henry Furman was a poor, uneducated African-American man. In 1972, Furman, who was only 26 at the time, broke into a home and killed the homeowner. The family quickly called 911 after realizing what had happened, and Furman was later arrested by the police. He argued that he tripped and his gun discharged, shooting the homeowner. William Henry Furman's trial lasted only one day. The jury was selected at 10 a.m., the evidence was presented, and the judge's instructions to the jury was given by 3:30 p.m., and the verdict was returned at 5 p.m. William Henry Furman appealed his conviction and sentence. His lawyer was Anthony G. Amsterdam. His lawyer argued that the death penalty violated the Eighth Amendment and the states must follow the clause of the 14th Amendment. Most poor, black, and uneducated men receive the death penalty more often. Amsterdam argued that the random, racial, unfair results made the death penalty cruel and unusual. It was 1972 when the Supreme Court ruled in Furman v. Georgia that the death penalty was unconstitutional under the existing statutes that were in place. The decision was 5-4, not on the violation of the cruel and unusual punishment, but how the convicted defendants were being chosen for the death penalty. There is a risk that the decisions made by the jury would be imposed in an arbitrary and discriminatory manner due to the fact that there was no guidance offered to the juries that were in charge of deciding whether to sentence the rapist or convicted murderer to death. The concerns of each of the justices varied. Brennan and Marshall agreed that the death penalty would violate the Constitution. Brennan argued that the death penalty violated human dignity. Marshall thought that the death penalty served no legitimate penal purpose. Both Douglas and Marshall argued that the death penalty was filled with discrimination, and those that were poor, powerless, or African American were sentenced to the death penalty more often. The justices concluded that the death penalty violated the Eighth Amendment as well as the 14th Amendment. The death penalty violated the Eighth Amendment by putting people through cruel and unusual punishment, and capital punishment violated the 14th Amendment's requirement of equal protection under the law. The 14th Amendment was violated by sentencing the defendants who were poor, uneducated, powerless, or African American to the death penalty more often than defendants not under those categories. After Furman's case, there was a lot of improvements made to the death penalty process. 39 state statutes were invalidated after the Furman case. This led to new statutes that were designed to avoid discretion and problems of arbitrariness and discrimination. There were two types of statutes, one that allowed the judge or jury to impose the death penalty on a defendant that was convicted of the first-degree murder, and the other statute permitted that the judge or jury impose the death penalty on the defendants who convicted crimes under certain circumstances. In 1976, the Supreme Court ruled these new death penalty statutes into play. Georgia, Florida, and Texas had statutes that correlated with the new requirements that did not violate the Eighth Amendment. It's now a duty of the jury to follow the legislative guidelines when a case comes up that is imposing the death penalty on an offender. There are some exceptions to the death penalty. The death penalty cannot be imposed on a defendant convicted of raping a child or an adult, those who commit felony murder, and those who are mentally handicapped. Furman's case made a huge impact on how the death penalty process is now dealt with.